Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
The Supreme Court will be taking up a gun rights case.
The court will consider whether people who use marijuana can legally own guns.
And this comes after a request from the Trump administration asking the high court to limit the right of drug users.
It's a case that legal experts will be watching closely when it likely heads before the justices.
Breaking news just emerged from the Supreme Court that should make every gun owner in America sit up and pay extremely close attention. The court has accepted its Second Amendment case for this term, and we're barely into the session. Normally, getting 2 gun cases in a single term would be cause for celebration among Second Amendment advocates. But here's the problem. This particular case might be the worst possible vehicle for defending gun rights that anyone could imagine. The defendant at the center of this constitutional battle isn't a law-abiding citizen whose rights were violated by government overreach. He's not someone like you or me who made an honest mistake and got caught in bureaucratic red tape. No, this is someone with alleged ties to designated terrorist organizations, someone who reportedly told law enforcement he wouldn't report an imminent terrorist attack if he knew about it, someone whose mother was captured on video saying she hoped her sons would become martyrs. And now this person's case is going to determine the constitutional boundaries of federal gun laws for millions of Americans. How did we get here? Why would the Supreme Court choose this case? And what does it mean for your Second Amendment rights? Let's break down what's actually happening and why gun rights advocates should be very, very nervous about where this is heading. The Supreme Court has just granted certiorari in its second gun case for the current term, which represents more Second Amendment cases than the court typically accepts in most years. Is that good news? Many legal analysts who follow these issues closely believe the answer is actually no, and understanding why requires looking at both the legal question being asked and the deeply problematic facts surrounding the defendant. The case we're examining is United States versus Hammani, and it presents a direct challenge to Section 922, subsection G, paragraph 3 of the United States Code, which is the federal statute that prohibits individuals who use unlawful controlled substances from possessing firearms. This law has been controversial for years, particularly as more and more states have legalized marijuana for recreational or medical use, creating a confusing situation where conduct that's perfectly legal under state law can still trigger federal firearms prohibitions. The core legal question is whether there's a historical tradition supporting the permanent disarmament of people simply because they use controlled substances, even when they're not actually under the influence at the time they possess firearms. We have clear historical precedent for disarming individuals who are actively intoxicated or under the influence of substances at a particular moment. That's not seriously disputed. But do we have any historical tradition that justifies banning people from firearm possession 24 hours a day, 7 days a week, 365 days a year simply because they use controlled substances at some point? That's the constitutional question at the heart of this case, and it's particularly relevant in an era where marijuana is legal in numerous states for adult use. The question often arises in the context of marijuana specifically because we now have a substantial number of states where cannabis use is completely legal under state law. So the practical question becomes, if somebody goes home on a Friday night, sits on their couch and smokes a joint while watching a movie, does that mean they should be legally prohibited from possessing firearms the other 6 days of the week when they're completely sober? Under current federal law, the answer is unequivocally yes. That single instance of marijuana use, even in a state where it's legal, federally prohibits that person from possessing any firearms. Normally, Second Amendment advocates would be extremely excited to see the Supreme Court taking up this case, especially given the current composition of the court, which includes several justices who have expressed support for robust Second Amendment protections. But here's where things go completely sideways, and why legal experts are warning this case could be disastrous. When Hammani was originally indicted under charges brought pursuant to 18 U.S.C. Section 922G3, the Fifth Circuit Court of Appeals actually found that significant portions of this law were unconstitutional as applied to his specific situation. That means it's the United States government, specifically the Department of Justice, that petitioned for Supreme Court review. It's the DOJ that was granted this appeal, and it's the DOJ that's now attempting to overturn the lower court's ruling that favored gun rights. Translation: the United States Department of Justice is absolutely determined to preserve and strengthen this federal prohibition, and they've chosen this particular case as their vehicle to do it. Anyone familiar with the Rahimi case will recognize the pattern here, and that case has come back to haunt gun rights advocates repeatedly in subsequent litigation. There's a principle taught in literally the first week of law school that every attorney learns. Bad facts make bad law. When you have a sympathetic defendant with clean facts, courts are more willing to protect constitutional rights. When you have an unsympathetic defendant with terrible facts, courts tend to rule in ways that establish precedent harmful to everyone else's rights. The Hammani case is absolutely loaded with bad facts that make defending Second Amendment principles almost impossible from a public relations and judicial psychology perspective. Let's examine exactly who Ali Hammani is according to the government's allegations, because understanding the defendant is crucial to understanding why this case is so problematic. Hammani is a dual citizen of both the United States and Pakistan, and his activities drew the attention of the Federal Bureau of Investigation for reasons that have nothing to do with simple marijuana use. In 2019, when his phone was searched at a border crossing, communications were discovered that suggested he was prepared to commit fraud at the specific direction of suspected affiliates of the Iranian Revolutionary Guard Corps, which is officially designated as a foreign terrorist organization by the United States government. So right from the start, we're not talking about your average cannabis user getting caught up in outdated drug laws. We're talking about someone with alleged connections to designated terrorist entities. But the allegations get substantially worse. In 2020, Hammani and his parents reportedly traveled to Iran specifically to participate in celebrations honoring the life of Qasem Soleimani, the Iranian general and designated terrorist who had been killed by an American drone strike the previous month. For those who don't recall, Soleimani was responsible for planning attacks that killed hundreds of American service members and was considered one of the most dangerous terrorist leaders in the world before his elimination. Attending celebrations of his life is not exactly the kind of background that makes someone a sympathetic defendant in an American courtroom. But there's more. Hammani's mother was captured on video telling an Iranian news agency that she prayed her two sons, including the respondent in this case, would become martyrs like Soleimani. His brother also reportedly has ties to terrorist organizations. Perhaps most disturbingly, Hammani allegedly told law enforcement officials directly that if he knew about an imminent terrorist attack planned by what he called a Shia brother that would kill innocent people, he would not report that information to authorities. Let that sink in for a moment. This is the defendant whose case is going to establish precedent about federal gun laws for millions of law-abiding Americans. Does this sound like your typical marijuana user who just wants to exercise Second Amendment rights? Absolutely not, because he's not. The drug allegations extend far beyond simple cannabis use. Text messages recovered from Hammani's phone showed that he both used and sold phentermine, a prescription stimulant, and that he found that substance addictive. He also reportedly used both cocaine and marijuana regularly. When the FBI finally obtained a warrant and searched the family home, agents discovered a Glock 9mm pistol, 60 grams of marijuana, and 4.7 grams of cocaine. During questioning, Hammani told FBI agents that he used marijuana approximately every other day. He also admitted that the cocaine found in his mother's room actually belonged to him. These are the facts that the Supreme Court will be considering when they decide whether federal law can prohibit firearm possession by drug users. The Department of Justice argued in their petition for certiorari that the Fifth Circuit erred in holding the Second Amendment precludes Congress from restricting the possession of firearms by habitual users of illegal drugs. The court's decision invalidates an important federal statute in the vast majority of its applications and exacerbates a multi-sided circuit conflict. This court should grant the petition and reverse. So here's the first major reason why gun rights advocates should be deeply concerned about the Supreme Court accepting United States versus Hammani. The facts surrounding this defendant are absolutely terrible for establishing good Second Amendment precedent. If you thought the facts in Rahimi looked bad, and they did, involving admitted domestic violence, the allegations against Hammani are arguably worse because they involve not just drugs, but alleged terrorist connections and statements suggesting he wouldn't report imminent terrorist attacks. These are not the kind of facts that make Supreme Court justices want to expand constitutional protections. The other gun case the court accepted this term is Wolford versus Lopez, which challenges Hawaii's restrictive carry laws. Even if gun rights advocates win that case decisively, it will primarily benefit residents of Hawaii and won't have broad application across the rest of the nation. In contrast, this challenge to 18 U.S.C. Section 922G3 could have massive nationwide implications. This isn't the only case working its way through federal courts on this issue, and for all the states that have now legalized cannabis for adult use, this represents an immensely important constitutional question affecting potentially millions of people. Yet despite the importance of this issue that's about to be argued before the nation's highest court, the vehicle carrying this question to the Supreme Court is someone with the background and alleged conduct of Mr. Hammani. Does anyone seriously believe the Supreme Court accepted this case because they're planning to affirm the Fifth Circuit and expand gun rights? The answer is obviously no. When the court takes a case like this, it's typically because they disagree with the lower court ruling and intend to reverse it. There's another critical consideration that gun rights advocates need to understand: bandwidth and opportunity cost. The Supreme Court has limited capacity in terms of how many cases it can hear and decide in any given term. We've now got 2 Second Amendment cases on the docket, which is already 2 more than the court accepts in most terms. But consider what's being left on the table. There are assault weapon ban cases currently working through the courts. The Viramontes case is pending before the Supreme Court right now. The Lamont case out of Connecticut is also petitioning for review. There will be numerous cases emerging from Illinois challenging that state's aggressive gun control legislation. Magazine capacity ban cases are also petitioned before the court, including Duncan versus Bonta, which many consider the most important magazine ban challenge, and other cases from various states. Does the Supreme Court realistically have the bandwidth, the energy, and the institutional willingness to take on a third gun case this term? The smart money says probably not. Courts have limited resources and political capital, and taking 2 Second Amendment cases in a single term is already unusual. By accepting Hammani with its terrible facts, the court may effectively be blocking consideration of other cases with much better facts that could establish stronger precedent for gun rights. That's the opportunity cost nobody's talking about. By spending judicial resources on a case involving an alleged terrorist sympathizer who used cocaine and sold drugs, the court may be passing on cases involving sympathetic, law-abiding citizens whose rights are being clearly violated. United States versus Hammani has now been accepted for argument before the Supreme Court. Oral argument dates will be set in the coming months, and the legal community will be watching this case extremely carefully as it develops. The stakes are extraordinarily high, not just for Mr. Hammani, but for millions of Americans whose gun rights could be affected by whatever precedent emerges from this case. The concern among Second Amendment advocates isn't just that they'll lose this particular case. That's almost certain given the facts. The deeper concern is how they'll lose and what legal framework the court will establish that will then be applied to future gun control challenges involving much more sympathetic defendants. If you have questions about this case or anything else related to Second Amendment rights and how federal gun laws might apply to your specific situation, consulting with an attorney who specializes in firearms law is essential. Constitutional rights are only as strong as the precedents that define them, and those precedents get established in cases exactly like this one. The next several months will reveal whether the Supreme Court rules narrowly, limiting their holding to the specific facts of habitual drug users with potential terrorist connections, or whether they use this case to establish broader principles that could affect gun rights for decades to come. Either way, this is a case every gun owner in America needs to understand, because the outcome will likely affect your rights whether you've ever touched an illegal substance or not.